So, Aaron, kind of talk to us a little bit about what's happening in that courtroom. What's going on?
Well, it looks like they've just probably done the first 3/4 of the charge conference, where the lawyers and the judge all fuss at each other, or agreeably fuss at each other, about what needs to be a part of the jury instruction.
We're off the record. We'll go to lunch.
So, and she's just said they're off the record, off to lunch. So, and the sweet court reporter sits there and takes it all down. But you notice during the charging conference, when the lawyers are both talking and the judge is responding, I feel like all three of them were talking at once. And then co-counsel would speak up, and then another lawyer would speak up. So that's the charging conference. They're just hammering out what instructions are going to go back to the jury after the defense rests and the state and the defense both close and do jury argument.
What did she ultimately decide?
The judge, I feel like the judge did not make a final decision on whether the lessers included will be sent to the jury. I know that the defense is asking for the jury to be instructed on not just the capital murder, but also the lessers of murder, burglary, robbery, and theft. And the state's response was, no, you aren't entitled to an instruction on a lesser included of murder because you've outright, there's nothing to show that that's a valid rational alternative to the capital murder. And the state kind of conceded that theft could be a valid lesser because there was some evidence, and through cross-examination the defense didn't concede necessarily, but there was something to show that the defendant did engage in theft, whether it's theft or theft by receiving or concealing stolen goods, that kind of thing. So I don't feel like the judge has made a decision on what lessers are going to go in the jury instruction. You may have heard differently than I, but I feel like
that's why I was asking you, because I didn't get the impression she did. It sounded like she was still kind of making up her mind. But you know how this stuff is. It's like you're trying to listen and everybody's talking kind of all at once.
Right.
So.
Well, yeah, and then I felt like the appellate prosecutor recognized that and said, you know what, Judge, how about the defense and we go and hammer this out and bring it back to you like in closer to final form, so that you don't have to listen to us go line by line, which was super considerate, because I'm sure the judge needs a break. Has the judge even stepped off the bench, but maybe once? Oh, they're talking again.
Oh, okay, here we go.
Yes, Mr. Chemirmir, you previously been sworn in, correct?
Yes, Your Honor.
And you're still that same person that was sworn in for a previous hearing, correct?
Yes, Your Honor.
And you've been present the whole time during this trial, correct?
Yes, Your Honor.
All right, so, Mr. Warren, you may proceed.
Thank you, Your Honor. Bill, you understand at this point, and as I explained to you, the state of Texas has arrested its case in chief against you. Yes, So that means that they presented all the evidence that they are put forth in the guilt innocence phase, meaning that they're done. You understand that? Yes, sir. So now it's our time and our opportunity, if we so choose, to put on our case in chief. Yes, sir. Based on our strategies that we've been working on since myself, Mr. Watson, and Mr. Hayes were first appointed to you on these cases, we told you if we didn't think the state could meet its burden, or if we didn't think they would get there, then it's our determination and our strategy whether or not we would put on any evidence. Yes, sir. But even outside of that, we also explained to myself personally, as well as Mr. Hayes and Mr. Watson, and even our investigator, Tanya Silva, that regarding your absolute right to represent you. Obviously, we could advise you. Obviously, we would advise you. We could tell you think it was a good idea. We could explain the risk, the cost-benefit analysis of taking the witness stand. I mean, you've sat here through 4 days of testimony, and you've seen and listened to direct examination and cross-examination. You sat in our diary and you selected the jury. And all the things that we talked about. Well, the same way, if you decide to take the witness stand, Mr. Fitzmar will have that opportunity to question you regarding certain things. You understand that, correct? Yes, sir. And we've explained that to you, and we've been talking about it since we set this trial date, since we started actually preparing for Dyer, and actually testimony this week. We've been discussing and talking that with you and through that situation. Is that correct?
Yes, sir.
Okay. And so now you understand we're at that point now that if you decided that you would like to take the witness stand, that it's up to you and you could. But on the flip side of that pillow, if you did not want to take the witness stand, the jury cannot under any shape, form, or fashion take that into consideration. The state of Texas is not be able to mention that regarding you testifying. And you also understand that, is that right?
Yes, sir.
So understanding all those things that we've discussed, not only here today, but over the last several years, and especially as we geared up and prepared for your trial, is it your wish and desire not to take the witness stand in your own defense?
Yes, sir.
Okay. And you're doing that freely and voluntarily, is that correct?
Yes, sir.
All right. Bill, if you have any questions or concerns or anything regarding the process, the procedure, or anything up to this point?
No.
Okay. I believe that's all I have now.
All right, thank you. So we have finished with the defenses. Anything else the defense needs to put on record? We're good?
I don't think so, Your Honor.
Okay, all right. So,
Just for purposes of scheduling, I'll let the court know that, so based on that decision being made, we do intend on resting.
okay.
When the jury comes back, and then we'll prepare to argue that after we reach our agreements or the rulings on the charge.
Okay, all right, and state, anything further?
Nothing further, Judge.
All right, thank you. So we will retire for lunch when we come back. When we get back on the record, we'll make sure to get all these things orderly and in fashion, so both sides can rest and close, and then hopefully we will have our charge ready, and we will go right into argument. We've already talked about the timing, and I would just ask if there's going to be more than one person arguing per side, just let the court know what that time is, and I will get to be the timekeeper.
Just looking, you have 10 minutes, Judge.
Okay, Aaron.
Yeah.
It sounds like we're going to go, the defense is going to rest and we're going to go straight to closings. Am I catching that right?
Yeah. I heard the same that you heard, and that's kind of what we predicted, that the reason they were doing this charging conference was because after the lunch break, we'd come back on the record, we would hear the defense rest, and then they'd be ready to rock and roll for jury argument. But what was also important was that during that moment, or those moments, we heard the defense attorney call upon his client to testify regarding his wishes not to testify. And so that kind of sealed the deal for us, that we knew Kobe was fixing to tell the judge that they were going to rest.
Wow.
Yeah.
I mean, I'm still kind of shocked that they didn't, get a medical expert or something up there. But it's just, I mean, that it just feels like they got nothing.
Well, actually, I feel like Kobe's cross of Dr. Bernard, that's all that probably they could have accomplished with a medical expert. Like, let's say they had called their own forensic pathologist to talk about, to pick at, to undermine, to call into question the Dallas County Medical Examiner's journey to their decision on the cause of death. Probably Kobe predicted and then did accomplish what he could accomplish through cross-examination of Bernard. And, I actually don't think it's a surprise that it was a surprise a little bit to me, because I thought they might rest after that FBI agent, but it's not a huge surprise for the state to end with Jeffrey Bernard, because he's the chief medical examiner, he's the decision maker, he's really well known in the criminal justice community as being pretty firm and obviously very experienced and very knowledgeable, but pretty firm. He makes the call, and when the call needs to be remade or reevaluated, he makes the call on whether to do that, and then that's that.
Yeah, because Jeffrey Bernard is not going to be intimidated into ruling it a homicide.
No.
That's just the way he is.
Yeah, no, Jeffrey Bernard is not going to be intimidated into reevaluating a case either if he has made the call and there's nothing. I think the way he talked about was if there's no new investigative information to redirect.
Hey, Rebecca. Hold on a second, Aaron. Hey, we're live. We're gonna actually break for lunch. Can we grab you and have you on right before we go live again with the. Hold on. I'll put you on speaker. Go ahead.
Okay.
All right, yeah. So defense attorneys just now were talking to Chemirmir and advising him, look, we've advised you not to take the stand, but, you know, it's your choice. And so he basically says he doesn't want to take the stand, and the defense turns around and tells the judge, okay, we're resting our case as soon as the jury comes back, so they are not going to present any evidence, and they're going to have closing arguments as soon as the jury gets back from lunch.
Yep, that's what we were just talking about. It's pretty. Aaron and I both agree that, in a way, it's not really all that shocking. I mean, based on the testimony.
It's not, but I'd be curious to know. I mean, would that in any way come up on appeal later on?
Hold on, let's ask Aaron that. Do you think this would be an appeal issue?
Well, no. So Kobe just covered the appeal issue. Kobe just put his client on the record to explore whether the client wanted to testify, wanted to exercise his right not to testify. And the way I heard Kobe ask the question, he kind of, I don't know if you heard this the same, Rebecca or Tanya, but I feel like he said, you know, you've told us that you didn't want to testify before, and are you still of that same opinion? Like, because really ultimately that's the client's decision. Are you saying, is there something to appeal because the defense isn't putting on any witnesses? I mean, not in and of itself, no, because the burden's wholly on the state, right? But when they put him on the record and asked him about that and gave him the opportunity to exercise his right or not to remain silent or testify, I feel like they covered it. That's exactly what just happened.
Yeah, and Rebecca, you can't hear Aaron, but basically what she said is that part of the reason they would go ahead and do that with him, you know, saying he didn't want to testify, is to cover that appeal issue. And also that, you know, it's ultimately up to the prosecution to prove the case. They don't have to put on a case. I mean, that's really what it boils down to. So, but I'm just going to be honest, we're going to go have lunch. So
okay, yeah, I'll call in because we did interview the families, and I'll fill y'all in then.
Oh, I tell you what, do just real quickly, tell us what they had to say.
Well, so one of the family members came out, and Dan Probst, and his case is one of the cases that has not been indicted, but in the death of his mother. But he said that there were literally gasps inside the room when they heard that Chemirmir had apparently, the cell phone records show that he was at the Walmart, then at Mary Brooks's house, and then 9 minutes later in the area where Dallas Gold Diamond Exchange was, and that he was basically selling the jewelry, according to prosecutors, right after she's killed. And he said that it was just like he went to the bank and then cashed their lives in, and so the families were just very upset about knowing that, because they feel like that's exactly what he did in their cases, and he'd been doing it for so long, according to them, from all the way back to 2015. So they were just, and they said that there's other cases that they feel if they can just get some receipts, if they had just gotten that one piece of evidence, that their cases would have been indicted. So they feel like there's at least 4 other cases where he could have possibly been indicted.
Well, and Aaron and I were talking about that, you know, that when you saw that list of transactions, that you know, assuming he's found guilty, that's like blood money. It's blood money.
Yeah.
You know, you go in and immediately pawning the stuff or selling the stuff. That's just it's pretty sick.
Very disturbing for the families.
But we're gonna wrap and so we can all go eat lunch, and then because you know we're gonna have a long afternoon. So anyway, all right. Hey Rebecca, thank you so much for calling in, and I definitely want to do this again towards the end of the day. Okay.
Okay.
I appreciate it. Thank you, my friend. All right. Bye bye.